Some of you I can tell on this training already know, but there's a few new faces. So it's a great opportunity for me just to tell anyone who's interested about my project. So basically it's a 2-year project. We're coming to the end of the first year. It is the housing campaigning project for both Ealing and Hounslow. And it is funded by the Trust for London, 2-year project. And it basically aims to give people from BAME communities the confidence and skills to have a voice when it comes to housing campaigning. We're already making some good inroads with Ealing Council, which has been chaotic to say the least in terms of their housing policy. Well, they don't have a local housing plan. And it's been very good working with Hounslow because they have been really kind of showcasing how a council should act and support its residents. There is a page on the website all about the housing campaign project, and it's also there's a toolbox which contains recordings of training that we run all this year to help groups and individuals campaign across a wide range of subjects, from digital media, report writing. There's a whole wealth of things in the toolbox, so do have a look at that. I'll drop that in the chat later. And Edmund kindly offered to host this session on the Localism Act, so that should fit in nicely with all the other training that we've delivered so far. So yeah, just a few house rules. If you can just keep yourselves on mute. I've seen lots of people have already, so that's great. And when you speak, if you want to put your camera on, if you're not, it'd be really appreciated. So yep, that's enough for me talking. So over to Edmund.
Good morning, everyone, and thank you for taking the time out to join us this morning on this look at the Localism Act. My name is Edmund, as Toby graciously introduced me, and I work with the West London Equality Centre as a legal advisor. I advise mainly in the areas of family law, welfare and benefits law, and housing law. And this morning, we'll be looking at the Localism Act. This act came into force in 2011, and it made very huge changes to planning law and housing law. And this effect continues to be relevant today. So I think nearly 10 years on, it's a good time to look at what the Act did, what effects, issues, and challenges it raised, and how we can use the Act to be able to support the housing needs of the people that we are assisting, whether as advisors or campaigners in housing and possibly planning issues. Okay. Can everyone see my screen? Toby? Good.
Yes, we can see it.
Oh, thank you very much. So today we'll be focusing on the Localism Act 2011. What is the Localism Act? What changed under it and why? What are the issues and the challenges that these changes then throws up in housing? And how can we use the provisions of this act to support housing clients within the Localism Act provisions? And then we'll have some views and discussions at the end of the session today. So the Localism Act, like I said, came into force and received royal assent on 15th of November 2011. Some parts of the Act took immediate effect and others came into force on later dates. The Act contains significant and enabling provisions for local authorities. Part 6 of the Act reformed planning law, and Part 7 reformed housing law, dealing with allocations, tenure, and also amended who can go on the housing list. This we will look further down in the course of this session. The measures under Part 6 include the abolition of regional strategies. This is the planning reforms. In favor of localized plans, it made a requirement for developers to consult communities before submitting certain planning applications, and for public bodies to cooperate in planning matters. It increased powers for local authority, planning enforcement departments, and for neighborhood planning to enable communities decide the future of the places where they live and work. The Localism Act introduced the Community Infrastructure Levy. It abolished the Infrastructure Planning Commission, abolished regional spatial strategies, and introduced neighborhood planning. So it took it from centrally planned designs to the local authorities to have more say in how the local government can actually develop the areas and the available land. The Act allowed communities to make neighborhood development orders and to draw up neighborhood development plans. This allowed local communities to be able to draw up their own set of general policies in relation to the development and use of land in their neighborhood. Under the planning reforms, the LA also allowed for community groups, including voluntary community bodies with a local connection, to be able to nominate important assets for protecting as assets of community value by the local authority. And I think in that regard, sometime the Southwark Town Hall was nominated as an asset of community value. Under Part 7, however, this is where we have the housing law reforms. The measures under Part 7 made significant changes to social housing allocations by giving local authorities greater freedom over who qualifies to go on the waiting list, though they are still required to ensure social homes are made available to the most vulnerable and those in greatest needs. So perhaps the most radical reform under the Act is the power it gave to social landlords to grant what is called fixed-term tenancies for new applicants entering social housing. Before then, if you are going into social housing, under the registered social landlords, known as the housing authorities, you will get what is called the assured tenancy. And if you are going into the social rent sector under the council-owned stock, you will get what is known as the secure tenancy. But that's changed. That was changed by the Localism Act, giving social landlords, be it the council or the housing associations, the power to grant what is known as a flexible tenancy. It's still a form of secure tenancy, but it is granted for a fixed term. The Act recommends that those fixed terms should not be less than 2 years. And we know also there is the introductory tenancy, which is granted for 12 months. So it kind of varied the tenor of security for people going into social housing. We will look further down at the implications of that and some of the problems that people may face when met with these flexible tenancies. So with the flexible tenancy, local authority landlords were allowed to provide a type of new tenants in addition to, rather than replacing secure and introductory tenancies. Private registered providers of social housing, that's the Housing Association, also became free to let their general need housing on existing assured short-hold tenancies. So under section 150 to 153 of the Act, the Localism Act placed duty on local housing authorities to prepare and publish a tenancy strategy. These strategies must set out the matters to which registered social housing providers must have regards to in formulating their tenancy policies. It didn't prescribe, though, how often these were to be reviewed. For example, Ealing's tenancy strategy was first adopted in 2012, right after the Act, and this went on until about now, 2021, when it's been reviewed. And I'm aware Hanslow has one also, but I'm not sure that has been reviewed recently. So the role of the tenancy strategies under the Localism Act is to set out the kind of tenancies the local authorities and registered providers in its borough may grant, the circumstances in which such tenancies will be granted of any particular kind, the length of any fixed term tenancy, and the circumstance in which a further tenancy will be granted when an existing fixed term tenancy reaches towards its review time. The Localism Act recommends that when a flexible tenancy is granted and it's running towards the end towards 6 months to the end of the tenancy, the landlord should give notice to the tenant as to what they are proposing to do with the tenancy, whether they're going to grant a further tenancy or they are going to grant a more secure tenancy or grant the same flexible tenancy, and then the tenant has the chance to request a review. And when that review is then done, the tenant should be informed, and this should not be later than 2 months to the end of the tenancy. And if it then becomes the case that they're not going to grant a further tenancy, the way to get the property off the client would then be by way of a court order following the normal possession proceedings. So regarding the allocation reforms under the Localism Act, Section 145 to 147 amended the law on the allocation of social housing contained in Part 6 of the Housing Act 1996. It gave local housing authorities the power to determine for themselves what classes of persons are or are not persons qualified to be allocated social housing in their area. We know that there's the 5 loops that applicants to get the main housing duty need to have. They need to be homeless, statutorily homeless. They need to have local connection. They need not to be subject to immigration control. They need to demonstrate that they haven't made themselves intentionally homeless, among others. So this would continue to affect the classes of people that would be determined to qualify for social housing. What they cannot do is to make it possible for people who are subject to immigration control to become qualified for social housing. And also it allowed them to take non-priority transfer out of the statutory housing allocation arrangement. So if you already have a secure tenancy, for example, and you're looking to transfer, you are limited in being allowed on the allocation register unless you fall within a specified group, and this will include the medical transfer or priority based on other consideration, such as maybe tenants that have been decanted. If you are under occupying, for example, and it is in the interest of housing stock management to transfer you to a property that is of less number of bedrooms that you are currently occupying, then it becomes possible for you to go on the allocations register in that instance. So going to the flexible tenancy again, the local landlords were allowed to provide a new type of tenancy, as we've seen, in addition to, rather than replacing secure and introductory tenancies. Private registered providers of social housing also became free to let their general needs housing on existing assured short-hold tenancy. Under Section 147, they earlier amended the law on the allocation of social housing contained in Part 6 of the Housing Act 1996 and gave local housing authorities the power to determine for themselves what classes of personnel are not persons qualifying to be allocated social housing in their area, and to take social housing tenants who are seeking non-priority transfer out of the statutory housing allocation arrangements. Section 148 enabled the local authority to fully discharge the main homelessness duty to secure accommodation to an applicant by way of an offer of suitable accommodation for a minimum fixed time tenancy of 12 months from a private landlord without requiring the applicant's arrangement. This is a huge change because before now, when you qualify, if applicants qualify for the main housing duty, it is the case that they would not be seen to have been discharged from the main duty to provide suitable accommodation for them until they are actually provided either an assured tenancy with the housing association or a secured tenancy in the local authorities' own housing stock. But the Localism Act changed that in that if you are secured a minimum of 12 months fixed term with a local landlord, then the local authority is justifiable in establishing or in taking it that the main housing duty has been discharged. And before then, if the applicant was unhappy to go into the private rental sector, they are within their right to refuse, and they will not be seen to have made themselves intentionally homeless. But the Localism Act changed that, in that if you are offered such a 12-month time in the private rental sector, under Section 193, 7B, 7E, the Housing Act 1996, a homeless applicant or the main housing duty can be made an offer of private rental sector by way of a qualifying offer, and rejecting it will not make them intentionally homeless. But if this happens since the Localism Act, then there's a risk that the applicant may be deemed to have been themselves intentionally homeless by refusing an offer of suitable accommodation in the private sector. However, if the offer of accommodation is not suitable and you follow the normal Section 202 review request, and it becomes the case that you are successful, then that will not terminate the housing duty of the local authority, in that the offer of accommodation in the private rental sector was unsuitable anyways. Under the Localism Act, as in law reforms, Section 149 provides that the main homelessness duty will recur regardless of whether the applicant has a priority need for accommodation. So going back to the example that I gave earlier, if the applicant was offered a 12-month fixed term in the local private rental sector, and within 2 years of accepting that offer, they then become they become homeless again, not intentionally homeless. So it can be because they have failed to pay rent, or because they have failed to do something they ought to do, or they have done something they ought not to do. Then, regardless of whether they have priority or not, they will then still be owed the main duty of helping relieve their homelessness. Section 160 of the Localism Act 2011, inserted for secure tenancies granted after 1st of April 2012, a new Section 86A, and basically limited the qualifying persons and the conditions under which they can succeed to a deceased family member's tenancy. This is very huge, and there are litigations on the back of this, in that there's a different regime for people depending on their circumstances and the family dynamics, making it kind of different, not only in the time that you signed your contract for your house, but also the kind of things that have happened within the family. If there's been a previous succession, for example, then it would no longer be possible unless the policy or the housing, the tenancy agreement with the landlord provides for a more generous succession plan. So you have the statutory succession, and you have what is called the contractual succession. So you, as the tenant of perhaps Catalyst, for example, may have in your contract Catalyst saying that in the event of a previous succession, they may grant another one. And A2 Dominion, on the other hand, might say one succession is all that they would be available. As we have seen, though the local authority has the duty to prepare the housing strategy in the local area, regarding the policies for the social housing providers, there's no power to force them to adopt this strategy. And therefore, they're still free within their own latitude to adopt their own specific housing tenancy policies. But usually, it is the case that they would they will have regards to the local authority formulated housing strategy. So before this change to the succession regime, a deceased tenant's spouse or civil partner or another member of the deceased tenant's family, which could include a cohabitee, can succeed if they had occupied the property for a period of 12 months preceding the tenant's death. Plus, where a tenancy agreement allows for additional people to be successors, this would usually operate as an allocation of a new tenancy and will carry further rights of succession on the death of the tenant. Now, post-Localism Act, the succession rights are limited to the deceased tenant's spouse, the civil partner, or cohabitee, unless the tenancy agreement, like I said earlier, expressly allows for someone else to succeed the tenancy. So this could be someone who is not even a family member, for example, a carer, and also where a succession occurs as a result of rights provided for in the tenancy, which I mentioned earlier is the contractual right to succession. It will operate as a statutory succession, and there are no further rights of succession, pardon me, please, succession in such cases. And also the Localism Act also affected the private property sector by introducing changes to the tenant deposit scheme. Section 184 of the Act made changes to the tenancy deposit provisions contained in the Asset Act 2004. These changes are mainly that the time for protecting the deposit was increased from 14 days to 30 days. Time for supplying prescribed information was also increased from 14 days to 30 days. This 30-day limit is absolute, and protection or providing prescribed information after 30 days will not prevent a penalty being payable to the tenant who has been whose tenancy or the provision for protection has been breached. So if, for example, the landlord receive maybe £1,500, for example, in tenant deposit on the 1st of March, you will have until the end of March thereby to protect that tenancy with one of the approved tenant deposit schemes. If, however, he fails to do so and maybe protects it on the 5th of April, the tenant would have a right to seek compensation from that landlord because clearly they have failed to protect the tenant deposit within the prescribed 30 days. And upon application to the county court, the court is open to, one, ask that the tenant deposit be paid as a fine, the total amount of that of £1,500 be paid to the tenant as compensation, or even up to 3 times that. But based on the short time lapse in this scenario that I've just given, it's unlikely that it will be up to that 3 times amount of deposit. On the other hand, if it's a more egregious breach, maybe the landlord has failed to protect the tenancy deposit for longer than 15 days, it's gone into several months, then it becomes more likely the case that the penalty for that breach may be as much as the 3 times upper limit that the court is allowed. Furthermore, when there are breaches of the tenancy deposit, the private landlord is prevented from issuing a Section 21 to the tenant, unless if they won't return that tenant deposit, or the tenant has successfully applied to the county court to have a compensation for the breach in the tenant deposit requirements. Also, the Localism Act reformed the time for supplying prescribed information. As we know, the private landlord is required to provide certain documents for the tenant upon the commencement of a new tenancy. This will include the energy performance certificate, it will include the gas safety certificate, and the how to rent booklet. So if any of these prescribed information are not followed, then it becomes the case that there is a breach of the Localism Act, and this will also affect the rights of the landlord to commence possession hearings by way of the Section 21. So as we have seen, the Localism Act made sweeping changes to existing housing legislations and the regulatory mechanism. The question then arises as to why these reforms were necessary and what complexities have they raised or solved in the social housing landscape. So let's look at that. The reality of the challenges in housing, in social housing particularly, is well known to administrators, to campaigners and applicants. The principal issue being the limited availability of social rent homes available, and the consequent high demand and the long tailbacks of persons waiting for social rented homes. As of March 31st, 2020, for example, Alien Council had 9,545 households on the General Housing Register waiting for social housing. For the year 2019 and 2020, there were just 821 lets into social housing. So we're talking about less than 10%. Of these lettings, 298 were to Alien Council owned stock properties, and 523 were to other registered providers of social housing. This problem is exacerbated by the high cost of alternative private landlord sector renters, and you may argue the quality as well. It is recommended that not more than 35% of the household income should be expended on rental costs, ideally. But the reality for most households is way higher. This here is the average cost of renting within London, 32 boroughs. So we've seen earlier that the ideal is 35%, but nowhere in any part of this would you find that in operation. It's gone from as high as 77% in Brent, for example, to Newham, 75%. In Ealing, it's about 62. And Croydon 50, Bromley 46%. So we're talking about huge, huge financial cost of housing. There have been efforts to try and ameliorate these. We have the London affordable rents that the mayor is championing. So local social housing in England is offered at different rent levels. The main rent level traditionally offered is for social rent at approximately a third of the market rate. In 2011, the government introduced affordable rent, which is slightly higher than social rent, with rents charged up to 80% of the market rate. However, the London mayor does not consider this to be affordable for most people, and funded an alternative London affordable rent, which is around 50% of market rates in Ealing. So against this background, one may see why the Localism Act sought to reform tenure in social rented housing to no longer be let on a tenancy for life, and by way of introducing the flexible tenancy for a fixed time, such that there are now a range of options available when issuing social housing tenancies, in addition to the periodic lifetime tenancies that were available for social housing landlords. So what is the importance of housing tenure? The security that it provides for people to know that the property that they're moving into is one that they can hold on to for terms that are longer than the 2 years, than the 5 years that are proposed under the Localism Act. Housing tenure describes the legal status under which people have the right to occupy their accommodation. Security of tenure is the recognized term for the legal conditions that offer tenants the indefinite tenure of their housing, subject only to proven breaches of their tenancy agreement that provide ground for determination by the landlord. And these are in Schedule 2 of the Housing Act, and some of these are what is known as discretionary grounds. Some are what is known as mandatory grounds, but that is more for another discussion. But under international human rights law, secure tenure is one of the 7 components of the right to adequate housing, which is linked to the right to the land. The other 6 components are availability of services, materials and facilities and infrastructure, affordability, habitability, accessibility, location, and cultural adequacy. So we've seen that during the flexible tenancy fixed time, possession is available on normal secure tenancy ground as long as there is a valid forfeiture clause in the tenancy permitting days. So a tenant may give 4 weeks notice if they are seeking to determine their own tenancy in writing to end the flexible tenancy during the fixed time. However, the tenant will be able to remain in social housing at the end of the fixed time. Whether or not they will be able to remain in that property if the landlord is taking action will depend on the landlord's own tenancy policy. The procedure for local authorities to then decide not to grant another tenancy at the end of the fixed time is as set out in the Localism Act, which we discussed earlier. If the landlord does not intend to renew the tenancy, it must give at least 6 months notice of this fact and 2 months notice seeking possession towards the end of the tenancy. The tenant has the right to request a review of a decision, of course, but there's no guarantee that that would be successful. However, the landlord, the social provider, is still required to seek possession through the mechanism of a court proceeding, an order, and a bailiff eviction in that sequence. So we will look at the issues and challenges that the Localism Act brought about in the social housing landscape. But I know I'm quite aware that this is legislation and it's not particularly exciting. So I'm happy for us to have a 15-minute break. And then when we come back, we can look at the issues and the challenges. Is that okay?
Yes, thank you.
All right, see you in 15, please. Okay, welcome back to it. Is that 15 minutes done? Okay, all right, cool. I hope we've all enjoyed our coffee and we are back and ready to plod on. It's difficult to assess how many people are really back. Can we just unmute ourselves for 1 sec to just acknowledge that we're back?
Yep, thanks very much for a quick break. It's a good idea. It's a lot to take in, very interesting. It's very hard to kind of see the application because, yeah, it's on one side, you know, really interesting things about affordable rent that the mayor suggests, and then the London affordable rent. And so it's interesting to see this, but thinking about how it isn't actually applied, it's yeah, it's incredible. So yeah, it's really interesting. I just wanted to check everyone's internet is okay, because mine was a bit wobbly, and I just wanted to check that everyone is able to hear and watch this all okay. So do shout out if you've got any problems, or great, someone's done the thumbs up. I was just concerned in case anyone else was having internet problems, and it was, as I'm posting this, I was thinking it was affecting it, but it sounds like it's all great. So yeah, thanks very much, Edmund. It's yeah, really interesting. Thank you.
Fantastic. Thank you very much, everyone. And then thanks for coming back early, and we can look at the specific issues that arises from flexible tenancy particularly. And then we will also look at issues around the succession rules and the issues around potential discrimination and human rights under the Article 8, respect for home and family personal life, and also the Article 14 of the Women Convention of Human Rights. So as we've seen in our discussion, the Localism Act made quite huge changes to the tenure and the security of tenancies by making it possible for people coming into social housing to have less than a secured or assured tenancy. And we've seen the importance of that security of tenure in people's confidence in their home and in the security that they have to be able to enjoy their tenancy and their property. So moving on, these reforms meant that each local authority area were able to include a range of different social housing tenancies, depending on the type of landlord offering them, and whether they have chosen to apply the available provisions under the Act on flexibility of tenure and of rent, whether to offer the social rent or the affordable rent or the London affordable rent scheme. For example, in Ealing Council, in its own tenancy strategy, it stated a preference for lifetime tenancies, which I would argue is perhaps better for reasons that we'll be looking at in a few seconds. So Ealing Council offered in the majority of circumstances, it should offer a secured or assured lifetime tenancy, but it also recognized that and considered that some registered providers may still wish to offer flexible tenancies to make best use of their stock and reduce under occupation, particularly when letting properties at affordable rent. But I believe strongly that there are other mechanisms to deal with under occupation for one, rather than granting flexible tenancies. Anslo, on the other hand, did not state such preference in its own tenancy strategy and continues to make flexible tenancies available for social housing providers. For social housing tenants, the security represented by their home can be an especially valuable good that can give those who have experienced uncertainty in their lives and turbulence in their relationship the secure basis from which to get on with their lives. The home is very important, that it is a foundation on which other things are built. Life aspirations, relationships, the outcomes of people are greatly tied to the security that they have in their housing situation. The security and stability offered by the social rental sector, which was frequently contrasted with the perceived insecurity of the private rental sector, therefore, provides an anchor point in life that often be in a state of flux and may be characterized by job losses, financial crisis, and or relationship breakdown. When people are confident about their residential security, they can then look to turn their attention to addressing other challenges in their lives, to get better training, to change jobs, to look at other life-affirming possibilities. Also, security of tenure goes to the heart of whether people consider themselves to have a real home. When people feel secure in their home, they often feel they can justify the cost and effort of making improvements and decorations to make it feel more like a home. They can personalize it if they know that they have a lifetime ownership, so to say, of that space that they live in, which will be quite different if you have a 2-year tenancy or a 5-year tenancy that there's no certainty of its renewal. Also, fixed terms are likely to cause particular anxiety to vulnerable tenants, such as people with learning difficulties, mental health problems, and physical disabilities, who may struggle with the practical process, such as providing evidence of continuing need. If you are going to, it has to be evidence-based. If the flexible tenancy comes to an end, for example, whether or not you continue to be in need is an evidential process. And therefore you need to provide justification by way of showing that you continue to be in the category of people that should access social rent. And therefore, people who have particular vulnerabilities may worry greatly about the potential outcome of tenancy reviews. Apart from the physical drain, there's the emotional and the psychological and traumatic aspects of it that is beyond just providing the evidence. And the more vulnerable people are, the more they would likely struggle in that regards. One of the main arguments for tenure reform is that social housing is a scarce public resource, which we agree. And that it should be focused on those who need it most for as long as they need it. But the larger question to be asked is how many fixed-term tenants will actually be able to enter into home ownership by way of mortgage in order to move on from a fixed-term social tenancy? Because ideally, everything else other than moving into your own home would be precarious, in that if you move into the private rental sector, the operation of Section 21 is particularly a drive for homelessness, because it is a no-fault ground for eviction. So it's not about what you've done or what you failed to do. If the landlord wants the property back, and it goes by way of Section 21. Unless there are procedural errors, there's literally no defense for it. And therefore, you find that it's almost cyclical, or is potentially cyclical, in that if you move from a flexible tenancy, for example, you go into the private rental sector, the end of the fixed time tenancy comes, the landlord issues a Section 21, you become unintentionally homeless. And therefore, if other requirements are satisfied, you come back as an homelessness applicant. And therefore, it's just almost cyclical if you follow my argument. Furthermore, tenants who are told that their fixed time tenancy will not be renewed and who cannot afford to buy their own property or are reluctant to take on a risky mortgage will have to move into the private rental sector. This indicates that flexible tenancies have the potential to create churn between two insecure renter tenants, whereby social tenants refuse a renewal of tenancy, will be assisted into the private rental sector with the 12 months fixed time that we discussed earlier, to make way for private rental sector tenants qualifying for an allocation of social housing. Then in another few years, then that process again might be repeating itself. There are huge costs to that. There are administrative costs. There are other associated costs. The administration and cost involved in conducting tenant reviews is also an issue. Every fixed time tenancy will require a potential resource-intensive review process to establish who normally resides in the dwelling and their financial means. Do they continue to meet the needs, the needs strategy, the practical needs requirements? Establishing this fact is much more complicated than it seems. It has emotional, evidential burdens to attach to it. And also, the cost is more than even the process of the evaluation and the assessment. This process will have associated cost in court proceedings for defendant repossession hearings. Very little of people who are given notice would move out at the end of their notice because of the implications it has potentially for whether or not they will be deemed to be intentionally homeless. So most notice for possession is not usually followed at the end of the notice date. It's likely to go into hearing. If it's defended hearing, the cost will spiral. Moreover, fixed-time tenancies are intended to generate higher rates of tenancy turnover. That's the purpose. That's the design behind them in the Localism Act, thereby increasing the number of vacancies, voids, redecoration costs, and relating costs at the end of each flexible tenancy. And finally, insecure tenure inevitably gives tenants a weaker contractual position in the landlord-tenant relationship. If you look at it, the tenant who has a flexible tenancy is in a precarious state because he knows that by a fruition of time, it's just a question of somewhere down the road that fixed tenancy will come to an end. And therefore, they may be less reluctant to join or support demands for improved services for fear of being perceived as troublemakers and therefore more likely to be refused a flexible tenancy renewal. And then also regarding the changes to subsection rules by the Localism Act. From the operation of the Localism Act, tenancies that started on or after 1st of April 2012, unless an express term of the tenancy permits for more than one subsection, once there's been a subsection, then that's the end of it. So For tenancies that started before that date, a contractual term allowed additional successions, which will give rise to a non-successory or discretionary succession. And the implication in this is that in certain circumstances, a succession is deemed to have occurred, barring a further succession in terms of survivorship, for example, where you have joint tenants and one partner dies, and the tenancy then needs to invest in the surviving partner. The statutory succession regime under the Arson Act 1985 differentiates between children of divorced joint tenants and children of deceased joint tenants, in that in a court-ordered property adjustment, the change of tenancy from one party to the other doesn't count as a succession. So even though there's been a transfer, there's been a change in the tenancy, a child of such a couple would have their succession rights preserved. Meanwhile, that would not happen where a party died and therefore the tenancy had to be transferred by way of succession rights to the other party. We will look at a few cases that actually examines that further. So a child residing with a divorced parent who becomes a sole tenant when the previous joint tenancy was judicially assigned to them on divorce, dissolution, or civil partnership, for example, can succeed to the tenancy when their parent dies. Because judicial assignment in this circumstance, as we've seen, does not count as a previous succession. Unless the former tenant was a successor, then they would have been to have succeeded the tenancy before, and therefore there can't be a second succession. It has been argued unsuccessfully, though, that the rule allowing only one succession unlawfully discriminates. For instance, in Simawi versus London Borough of Haringey, 2019. This was a challenge arising from a possession claim to the one succession rule on secured tenancy. And these are the facts. Mr. S was the son of Mr. and Mrs. Simawi, who were the joint secure tenants of a Haringey property beginning in 1994. So this is pre the Localism Act. The father died in 2011, and Mrs. Simawi became the sole tenant by succession. Mr. S died in 2013, and 2 months later, Haringey served notice to quit. So this is what we discussed a minute ago about the different operation and how there's potentially discrimination in how it operates. So dad died, there was a transfer of the tenancy to the mom, and that was the succession. The mom died in 2013, and Haringey then served a notice to quit because there can be further successions on that property. Mr. S then brought proceedings against Haringey. At the first hearing, the possession order was made. He appealed. This was overturned on appeal to a circuit judge. Then this went further up to the Court of Appeal, which eventually held that there was no discrimination, and Haringey were justified in seeking possession under the circumstances. And also in Tully and Wandsworth, this was a challenge arising from a possession claim to the one succession rule on secure tenancy. Mrs. Tully cohabited with Mr. Doyle for many years in a 4-bedroom Wandsworth Council property. They had 4 children together, though they weren't married. Their relationship broke down and Mr. Doyle moved out. However, he returned in January 2012, just 2 months prior to his death. So Mrs. Tolley applied to succeed the tenancy under the circumstance. Wandsworth Council refused because though a cohabitee could succeed a tenancy, in this scenario, they haven't lived together for the required 12 months because he had moved out, and arguably that has broken the chain of their cohabitation. And therefore, Wandsworth held that Mrs. Tolley does not qualify to succeed that property. Ms. Tolley appealed to the Court of Appeal. This was dismissed. And it was determined that the 12-month rule was a legitimate way of establishing that couples were living together in stable and enduring relationship. This was a reasonable foundation for the rule. The subsequent changes to the Localism Act and proposed in the Housing and Planning Act 2016, this proposal is seeking to make it a uniform succession rule pre-2012 tenancies and post-2012 tenancy. And the court held that this did not invalidate the current or the previous regime. So bringing all of this together, in view of the operation of the Localism Act, housing professionals in assisting their housing clients need to be looking beyond the tenancy agreement when situations or issues arise, maybe in possession hearing, in succession issues, in eviction, neighbor disputes, antisocial behavior. We need to be looking beyond the tenancy agreement. I would suggest that, plus the tenancy agreement, we should be looking at the landlord's letting tenancy policy, be looking at the local authority tenancy strategy. Of course, this will be different when it comes to advising clients who are in the private rental sector. But we've seen that the reaches of the Localism Act extends to that sector as well in regards to the tenancy protection and the power it has to influence whether or not a notice seeking possession or an application for court proceedings will be valid or not. And this is where we move to the general discussion aspect of today. And I'm happy to take questions. And if I'm unable to answer your question immediately, I would, Toby has my email, and I'll be happy for you to send questions by email or to repeat those questions, and I would answer by email. Thank you very much, everyone.
That's really interesting. A lot to kind of understand, but yeah, gosh, I mean, it's so difficult for even if you're working in this area to understand the complexities, let alone people who want to try and challenge and move things forward without kind of professional help and support. So yeah, who's got a question for Edmund? Shelley? Yep, go ahead,
Hello,
Shelley.
Shelley.
Sorry.
Yes, Shelley, please. Yes.
Oh, hello. Thank you. Thank you very much, Toby. And thank you very much, Edmund. You know, oh my goodness me, I really applaud you for how you have explained the Localism Act.
My pleasure.
You know, I mean, indeed, it is I am familiar with the Localism Act, and it is really mind-boggling, frankly. You know, yeah,
Good way to describe it.
Yeah, the trouble is that if I can, because you see, you know, with the pandemic and with the problems in society, Sorry, I'm just going to get a little bit more comfortable, if that's okay. Yeah, with the problems in society, I think that the reset button really needs to be pressed in terms of our civic institutions, because it seems that all of this legislation is actually rather conflicting. So one act supports people who have needs, and another denies. And that is a person who is in that situation, particularly people who are on benefits or with disabilities or with, from the disadvantaged sectors, we may say, they do not know what all of this means. They are just lost in the system. So I don't know if you've noticed on the chat, I sort of made some comments. I refer back to the Local Government Act 2000, Section 2 and Subsection 4. And why I'm doing that is because at the end of the day, the Localism Act that you have sort of explained to us, it provides the local civic institutions ways out of actually meeting the duties that are detailed in the Local Government Act 2000. The clear duty in the Local Government Act of 2000 is that every local authority is required, not optional, it is required to develop and formulate and effect policies that meet the needs of the local demographic. That is what Parliament requires local authorities to do. So aside from the examples I've given on the chat, if I just give one example. Internationally, there has been talk of of every single citizen being given a fund, e.g. £1,000 per month. And within that £12,000 per annum, every person gets that £12,000. They then can choose to earn an income if they want, if they can, and it does not impact on the £12,000. They get that 100% without question. Everyone does. Anything they earn on top of that is theirs to keep. Within £12,000, if they cannot earn or don't want to or whatever, they have to manage. So a couple, that's £24,000. And internationally, this amount is regarded for the UK to be sufficient. Now, if I were to have a conversation, you were to have a conversation, Toby was, anyone was, with the local authorities cabinet, indeed leader, the leader could, within a month, under the Local Government Act 2000, bring in this policy, even as a pilot scheme. They could say that, okay, in Ealing, we're going to trial this. And there is not a law that would deny them that privilege. They can do it by the stroke of the pen, if there was a will to do it. That's the problem. In New York, a mayor, or maybe not New York, but in America, a mayor trialed this policy. The effects of that were that all of these people that are chasing fraud within the benefit system, all that stopped. People were free. You know, they actually didn't have the stress of worrying about what rule they had broken or hadn't broken. You know, they were free. They got they've got their living sort of wage, if you say, and then they're free to earn as much as they can without any penalty. And imagine just that example, if we had that situation here in Ealing today, I mean, life would just be idyllic. But it's not. The governors, our local leaders, they prefer to entangle people into all of this mess in order to avoid performing their duties. And that goes back to the Local Government Act 2000. On the local radio station, which is Desi Radio, the Punjabi radio station, there are sort of notices, oral notices being issued that in Southall, an employment scheme for those between these ages on these benefits, they will be helped into employment through free courses, you know, sort of vocational courses. That's not open to anyone who doesn't live in Southall. And that is because it is a locally specifically designed policy to help people from the disadvantaged sector within those parameters, and that policy is formed by Ealing Council under the Local Government Act 2000 Section 2. Again, you could do any policy, the council could do any policy they liked that would help people meet the needs of their demographic, would support the vulnerable sectors if they wanted. So the the local authorities choose to rely on the Localism Act 2011 because it entangles those that are suffering most. Joe Bloggs on the street, he is not going to, this is all double Dutch to him. He just wants his problem solved, that's all. He doesn't want to go to the High Court to deal with these issues and then lose and still be in the same mess that he was in 18 months before. It's all a nonsense. So I'm sorry I've taken up too much of your time, but my plea is to all of us who are working in this sector to help the vulnerable societies, that we return our governors. We you know, sort of call out to our governors that, look, this is all nonsense entangling us up like this. Come back to the Local Government Act 2000. That is where your duties are, and that's what you need. It's high time, 21 years, nearly a generation, that those policies are being developed that work against the interest of Joe Bloggs on the street. Okay. Many policies, all such you have mentioned, Edmund, you know, the spare room policy, for example. I mean, Parliament's Race Disparity Unit has identified that through this policy, the contagion did not desist. Because where are people supposed to self-isolate if they haven't got a spare room? And so, you know, as I mentioned, my plea is to all of us who work in this sector to help voluntary people, to help the disadvantaged people, that please, we need to call out our councillors that come back to the Local Government Act, please. Thank you very much for listening. I appreciate that.
Thank you very much.
Yes, really interesting points. I see Amal's put a question in the chat. If a single mother had the tenancy but passed away and doesn't have relatives who can take the tenancy with children, can the older daughter who's adult be the tenancy?
Okay, yeah, I'm happy to take that. I would assume that this is a secured tenancy or an assured lifetime tenancy? And the answer to this really would depend, as we've seen, on when that tenancy was signed, when it commenced. So if it commenced before the Localism Act, then there's the daughter has lived with this single mother for a continuous period of 12 months preceding the death, then she can certainly succeed that tenancy. On the other hand, if this happened post 2012, then it would depend on the tenancy agreement, then the policy of the landlord on succession. And so, and what in this case, she's a single mother, so we don't know the circumstance under which she inherits that property. Did she get it as a single mother, or there was a relationship breakdown before, and then she becomes the sole tenant? So has there been a previous succession under the regime of the Localism Act? So that would probably need further examination of the fact to be able to come down conclusively if the succession rights are still available.
Okay, that's great. Does that help, Amal?
If Amal is there, we could examine the facts further and look at the dates and the circumstances.
Okay, I'm going to put your email address in the chat, Edmund, if that's okay. And I also put in the chat just the feedback link. So if I can just encourage everyone to just take a couple of seconds to fill that in. So we've just got a couple more minutes. I'm just going to pick on a few people to see if they've got any comments or questions, and I'm going to pick on, if he's still there, Arthur. Are you still there, Arthur? Have you got any questions? No, maybe you got called into something else. Is there anyone else with a question for Edmund?
Can I?
Of course. Hi, Kelvin.
Hi. Yes, so sorry, for those who don't know, my name is Kelvin from Cape Mental Health Charity, but this question is not specifically about that. I guess anyone who lives in Ealing will know that there's been a lot of development going on recently, a lot of housing development. One of the things that I'm just been that's been on the back of my mind sort of throughout the presentation is what role have developers have in this as well? I mean, it seems to be like an important facet to this as well, especially when there is this idea of X amount of social housing is supposed to be made available in a lot of these developments. I guess the question is that happening, I suppose? And just my kind of sense of the Localism Act, it does seem to be a rather not very successful attempt to sort of cover up the lack of stock generally. So yeah, that's sort of comment and question really.
Thank you very much, Calvin. I mean, you've raised very valid concerns, and this is quite, I would say, an issue that is pressing and evident in the built environment. The Localism Act, particularly under the planning reforms, requires that developers must have consultations before these developments are even commenced, and people would have input as to whether or not that development meets the development plan of that local area. There's also the community infrastructure levy. And part of this requirement is that certain aspects of that development should be made available to people on social rent, on affordable rent. We've seen that social rent and affordable rent are quite different regimes. And it's argued that what people actually need is social rent, not affordable rent, because of the price disparity that that these regimes come with. And therefore, it's the democratic process in there, in that when those consultations are held, are people's view carried forward into the final plan? And there's a very strong view that this is actually not so, that developers continue to get away with the M word, you know, almost as it were. And sometimes also you find that when this community infrastructure levy are built into the, say, a percentage of the houses needs to be made available at social rent, you find that the quality, the layout, the space availability of these social rents are so disproportionate, or in terms of quality and value, to that which is made available to other people, which continues to make a mockery of what the plan or the intent of that legislation is.
Okay, well, that's great. So we're going to have to wrap it up now. I hope you all enjoyed that. A lot to think about, and make sure you come to the Community Advisory Board meeting. I'll put some information. I have been promised by Councillor Mahmood that he's going to get some big wigs from Ealing Council along and developers, and fingers crossed he does. I feel like we're making inroads, so it'll be interesting. We also have a charity, an organisation called Ethical Housing Organisation, that give advice to groups, not only just about their own housing, but how they can give advice to individuals with housing issues and concerns. So they're confirmed, and hopefully some interesting people from Ealing Council, so we can put lots of questions to them and put them under the spotlight and question them a bit more. So so I hope you can all join that. But yeah, and it just, all that needs to be said is thank you, very big thank you to Edmund for delivering that. Yes, that's such a lot to think about, and yeah, you know, thinking about what Shelley says, it is mind-boggling. I wasn't expecting it to be so complex. But yeah, a lot for us to think about, and think about how it kind of impacts some people in the local area. But yeah, thank you very much to Edmund, and thank you very much to everyone for joining. See you all soon.
Enjoy the day. Thank you, everyone.
Thank you.
Thank you. Thank you, everyone.
Bye.